new names so I don't have to call on the same olds anymore. Rigo, you're off the hook. All right, we're going to revisit this one. We've got a few wrinkles in this problem. We've got our agent who's in the barn. The agent has entered there lawfully to get food and water. He or she has found a horse. The horse is standing next to a stock tank. Agent approaches and finds the tank is empty. He sees a water hydrant, to answer your question, Bobby, and a hose goes to fill them up. The agent approaches the water hydrant and notices a border collie lying in the corner of the barn. The dog is clearly injured with what appears to be a broken leg. It is emaciated and panting heavily. The agent draws nearer and sees 3 puppies lying next to the border collie, one of which appears to be dead. What can the BAP agent do? Before we talk about this, I want to talk a little bit about horses in the context of when is a horse livestock and when is a horse not. So 3542, which is your enabling act, defines livestock to mean cattle, swine, sheep, goats, and here's where we get into the horses. I'm going to skip over the other pieces, the other animals. Such horses used in the farm or ranch production of food, fiber, or other products as defined by the commissioner. And I guess I should just read this. And such horses, mules, asses, and other animals used in the farm or ranch production of food and fiber. When we get to horses, that's what we look at there, is how do we know and what do we know about the use of this horse? Is the horse used even once to go out and to round up cattle in the fall? Is the horse used to ride the range and check fences where the cattle are kept? Is the horse 100% a pleasure horse? If it's used even once a year, if the person can legitimately say, this is my cow horse or this is my range riding horse to check my fences, that's a horse that's used in the production of food, fiber, or other products defined by the commissioner. Used in the farm or ranch production of food, fiber, or other products. If the horse is entirely a pleasure riding horse or for the person's companionship, that's a companion animal. This is a tricky situation. I know CHS deals with this a lot because they are really the big helper of abandoned horses. And if you have questions, it's really important to get with Becky or to get with your prosecutor to figure out what evidence you're going to do, what evidence you're going to gather and how you're going to gather to make that determination. Err on the side of caution. This situation here, thank you, Bobby, we have a horse, not a llama. You're going to approach this thinking it's a head of livestock. You don't have any other knowledge about what it is or isn't used for. You don't want to make the wrong mistake, so make the one that you can defend whatever it is. We're going to call it livestock for purposes of this hypothetical. So what we have here, right? We have a livestock horse and we have companion animals. So we have a complicated situation in this scenario. What can the agent do? We're going to jump over to our friend Kathleen and say, Kathleen, what first of all do you see are the relevant factors in this hypothetical?
And actually, can I make us pause for a second?
Oh, sure.
Because CSU Spur says someone's car is in a place it should not be. So let me make a quick announcement.
Yeah,
That's okay.
yeah.
Sorry about that. It's a Ford Fusion license plate DAM 614, DAM 614. Whoever's car that is, if you don't mind going out and moving it right now.
Does the fact that it has government plates get us out of this?
Is that your car?
Yeah, it's my state car.
Oh,
It's not posted. Becky, can you move that? Oh my gosh.
All right, continue.
The good news is CSU and CDA are really good friends, so they didn't just tow the car. Okay, Kathleen, you were going to give us the relevant facts here.
You have a companion animal, so as BAP, you are able to help that animal more, be able to start photographing, collecting your evidence for just the companion, but I would also still call law enforcement and make sure they're okay with you doing that.
Yeah, that's a really good answer. And I just sent our microphone out of the room, so I'm going to repeat that. So, Kathleen, pointed out that this is a dual livestock and companion animal. With the companion animal, there's a bit more authority for BAP agents. There's a bit more authority for BAP agents, but we have the complicating factor of there also being livestock. Kathleen suggested she would get in touch with law enforcement immediately to start the process because there's livestock, understanding that she does have some additional authorities with the companion animals. All the while, she would go ahead and start collecting some photographs and making notes and impressions of what's going on before her. That's a very good answer in this particular situation. The analysis, again, the horse problem is solved. The water, you can give water to the animal post-notice upon your departure. The border collie appears to be neglected. Puppies may not be receiving necessary nutrition from the mother, potential for starvation. I think we said we had one that was already deceased. Call law enforcement. Get on the phone with Becky immediately. Loop the BAP program manager in there to see, so that we can be in touch as well with law enforcement, all three of us, the agent, law enforcement, and Becky, to try to reach a concerted plan that's going to most effectively and efficiently respond to these animals. Can you take the dog or puppies? With permission from CDA's Division of Animal Health or the BAP program manager, you can. We're going to talk a little bit more about the takings in these scenarios with companion animals. Kathleen, you have a question.
I have a question about posting the notice of entry and care for the dual, since we run into that a lot. Hypothetically, law enforcement's on their way. Is that a question to ask them if they want us to do two postings, one that they provided for livestock or that we provided for all animals? Is that a jurisdictional question, or is what is better from the CDA side?
Yeah, and that's a good question, Kathleen. Let's assume, for purposes of your question, that that horse doesn't have a broken leg and that puppy was just asleep and not dying, and all you really did was give it food and water. I don't have a single problem with a single solidified, consolidated posting notice of entry of care. I, Kathleen, was here on this date. I gave the horse water and hay. I gave the puppies and the mother dog. I gave the mother dog water and dog food. I gave the puppies, water if they could drink it. They may still have been nursing. If law enforcement comes bearing warrant and removes the animals, you don't have any need to leave a notice of entry and care because there are no animals there anymore at that point in time. That person's going to receive a summons and complaint. If Becky and I have worked together and the commissioner's on board with taking the puppies separately under the commissioner's authority, that person's going to receive a notice, a summons from us to show a summons. We're going to serve them with an order to show up in court and articulate why he or she is fit to own those puppies and that dog. So really, your notice of entry and care is only when you've entered and you've left the animals there. There's no concern for their immediate health and safety, but you did provide food and water. Thank you. You have the microphone. Do you have a question?
Yes, I do. So you go in there, hearing the horse pawing at the trough. You go to give water to the horse. You find the border collie. At that point, you need to return to your vehicle to get dog food and a bowl possibly to give the dog food. Is that okay?
That's okay. I think you're still in the process of providing food and water. You were there because you heard livestock. You were there because you heard what you thought was an empty stock tank. When you got into the room, you found not only was there an empty stock tank, but you also had a companion animal that didn't have food and water. You brought your 5-gallon bucket, but you didn't bring your kibble with you. You've got kibble in the car. You're going to go back and grab the kibble and take it out. You're still there for the same purpose. Post your notice of entry and care. You're out the door. You're on your way. Coming back 24 hours later to see how those animals are doing, assuming they're not in a dire situation. Other questions right now? We're going to a few more facts here. And this number you should take down if the program manager is unavailable. Call CDA's veterinary number. Dr. Vaden, can you clarify, is this number still valid? 303-869-9130?
That's not my work number.
Okay.
I'll provide my work number.
Okay, so Dr. Vaden, when we did the slideshow initially, Dr. Vaden wasn't part of the team. Dr. Baldwin in the corner, as the state veterinarian, will know what the number stands for. Okay, that's the main office number. Okay.
After hours, you'll get the Social Security time to reach out to the not available. That's the main office number. After hours, he'll leave the veterinarian
Okay, and let me repeat that for the audio. This is the main office number to the Office of the State Veterinarian. After hours, there will be a number provided that will give you the veterinarian on call, whom you can call. In addition to that, Dr. Vaden, at the close of your presentation over this training over the 2 days, will give you her contact information. When we initially did this presentation, Dr. Vaden's position, not only was Dr. Vaden not there, but Dr. Vaden's position hadn't been created. So now we have a dedicated veterinarian for the Bureau of Animal Protection, and she will be able to, she will make it so you can make contact with her. Okay. Okay, any questions on that hypothetical? We're going to move on. We're going to do one more wrinkle. New York City. Okay, who remembers the Pace Picante commercials? Thank you, Bobby. Okay, good. A few of you do. Go to YouTube, look at them. Pace Picante, New York City, ? You'll get a great series of commercials. Then you'll understand why this is funny later. Okay, after receiving a call from the BAP agent, the Powers County Sheriff dispatches himself to the barn, warrant in hand. Our fearless sheriff, unbeknownst to anyone in Powers County, is part of the Federal Witness Relocation Program. He's relocated from deep within the bowels of New York City, where he lived a life sheltered from ever seeing any kind of livestock, let alone a horse. That's a stretch. Thanks, Bobby. It's your fault. Upon arriving at the property, he sheepishly admits all this to the BAP agent and asks the agent to assist with the investigation at this point. What can the BAP agent do? Alex, what are you going to do?
I can advise him as to how to handle it,
Good.
but tell him that my authority, I can't investigate livestock.
Okay. What role do you think you're going to play with him as he's trying to, he knows nothing about horses. You've got a horse that you think has a broken leg.
I'm going to ask him if he can see that the horse has a broken leg.
Okay. Good. What evidence do you think you're going to help him maybe gather? What do you think would be useful to him in terms of getting the district attorney to prosecute the case?
Just everything that we're observing. I would tell him to document everything before changing the scene or anything like that, before removing anything. We need to, I've obviously taken documentation, but he needs to take some of his own as well.
Good. Okay. All right. Good. AJ, what about the puppies? What do you think you're going to ask the sheriff to do and gather in relation to the puppies?
Who was it?
AJ's over here. Hold on one second.
Document photograph system. Hopefully he's dealt with puppies in New York. But at that point, because it is a companion animal, depending on what the warrant has, you could assist even with transporting at that point to a vet if it rises to that level.
Good. What about cost of care? Are you going to help him impound, perhaps?
With that part, yeah, put him in touch with the DA and the court so the cost of care is started or whatever their policy is through their sheriff's office.
Good, right. A lot of you will run into situations, and Tara touched on this yesterday. Your prosecuting attorneys don't understand cost of care, right? Your local law enforcement don't understand cost of care. This is another really good role you play, is articulating what this is and how it works, and what that form is that you're going to file and what the rights are that the person has. Oh, by the way, there might be a hearing within 10 days' time if the person shows up. Be prepared for that. Madam Prosecuting Attorney, Mr. District Attorney, this is what's coming down the pike with this. You guys are the ones who have a lot of information, and your role at that point in time when you're dealing with the sheriff who doesn't know anything or the investigator who doesn't know anything is to help them. What is the evidence? Where's the moldy feed? Where's the bad water? Take a photograph of that stock tank that is bone dry. Not only is there not any water in the bottom, there hasn't been water in the bottom in a long time. Let's get some good photographs of that broken limb. Let's get a photograph of how this animal is tied up to the wall or the whatever it's held to. Janae, are you stretching or raising your hand? Okay. Hold on one second. Let's get you a microphone.
Workout today, Billy. Your car's moved. Doing smiles. All right. Here you go, Janae.
So I just wanted to go back to the livestock. If Alex is out there helping or he's asking to assist, for her to assist, Would there be any problem with her taking the appropriate photos and doing that documentation and explaining that process? Because I think, you know, it's very unique in what the types of photos that you have to take with animals and how to get those angles and that sort of thing. And to try to walk him through that might not be feasible.
No, I think, yes, once he's there and he says, we need to investigate this. And that BAP agent says, great, I've got my phone, do you want me to take photographs? Yeah, please, take the photographs, you know what you're doing.
Okay.
Mrs. BAP agent, what do I need to get from this scene? I want you to take that piece of food. There's mold growing on that hay over there.
Okay.
Yeah.
I just wanted to be clear because it sounded like she was going to walk him through that whole thing. And I mean, you're the expert, right? We're the subject matter experts. So why wouldn't we just take the bull by the horns and help so it's a good case?
Yeah. Don't usurp his authority by any means, or her authority, but offer assistance. Hey, I've got my phone. I know what photographs need to be taken. I've prosecuted a case, or I've worked with a prosecution who prosecuted a case like this very similarly, and these are the photographs that worked really well for us. Great. He's going to say, start taking the photographs. Help me out here. So, good. Yeah. Other questions? All right. Yeah.
So if we have the authority for the dogs, right, because they are companion animals, like, can we investigate the dogs on our own, or like, why would we have to involve the sheriff?
Well, so you may not have to involve the sheriff, but here's the situation. If you've got the sheriff coming out for the livestock, you may want to have a full-blown criminal investigation and ultimately get a conviction on the criminal side. The commissioner authorizes you to take the puppies out of there, which may well be what the commissioner says. When you call Becky, she calls, Maggie, Dr. Baldwin, and they say, yeah, separate from what the sheriff's doing, let's get those puppies to a shelter immediately. Becky calls me, okay, the commissioner's green-lighted this. Okay, we're going to have two separate trials going on at the same time. The commissioner of agriculture must, and we'll get into this, hope we don't run out of time, the commissioner must go immediately to court anytime the commissioner takes a companion animal by BAP agent or by staff to petition the court for a hearing to determine whether the person from whom the commissioner took the animal is fit to own the animal and is able to adequately provide for the animal. That's just a question of fitness of ownership. So we make a determination the person's unfit to own the animal. Maybe law enforcement says, well, we've taken care of the dog, we're not going to prosecute cruelty there. Maybe somehow we lose the fitness of ownership issue, and the DA says, well, if you can't prove your civil case with a lower burden of proof, I can't prove my criminal case by any means, and you've just foreclosed me from doing that. So in this situation, which is why why I did the hypothetical with a mixed livestock companion animal, is you probably want to make this as rock-solid criminal as you can so that you're not going either way. But yes, to answer your question, the commissioner does have authority. The commissioner can authorize you to remove those from that property, and we'll jump into the civil side and prosecute as necessary. But the commissioner has an adamant, the commissioner can't just dismiss a case. A prosecutor can look at a sheriff or an investigator and say, I don't like your evidence, this case stinks. The elected DA can have political reasons for not wanting to prosecute. They're going to dismiss the charges. On the commissioner's side, there is no dismissal of charges. Once that animal's taken, the commissioner shall petition a court for a hearing, for an immediate hearing, on the question of whether the person was fit to own and whether the person is able to adequately care for. So, all right. Other questions? We are running out of time, and we've got a lot to get through. Okay, so you're going to expertise, information, description, knowledge of species and its needs. Are you the investigator? No. Are you helping with the investigation? Yes, that's fine. Do it. Take the photographs. Write the information down. Feed into the report. The sheriff or the investigator may have you do even more with regard to ghostwriting for him. Fine, ghostwrite. You're going to be on the stand. You're a witness. We just want to be clear when you're on the stand that you were not affecting the investigation, which could trigger the exclusionary rule, which could mean you'd lose the entire case or not even get into a courtroom with it. All right. I think we have almost beaten this dead horse, but really quickly, civil and criminal comparison. This is kind of how it starts out. Civil investigation, criminal. Civil side, we can get search warrants. Administrative, I don't know why that says we're criminal. Administrative, search warrant on the criminal side is criminal. I want to talk about administrative search warrants. Regulatory authorities are authorized to enforce, to ensure that the provisions of the Regulatory Act are being enforced. Doctors, veterinarians, any licensed individual is covered by a regulatory act. The Department of Agriculture, Title 35, creates a series of regulatory acts, one of which is the Bureau of Animal Protection. The General Assembly has given large administrative search warrant authority to regulatory bodies for the purpose of ensuring that the Regulatory Act is being complied with. Now, what does this mean? You go to Becky and you say, look, I'm going to use PACFA because this is the easiest example. PACFA, okay. PACFA has evidence. PACFA has a serious concern that there's a facility that has 17 dogs. It is unlawful in the state of Colorado to have 17 dogs in a facility without a pet animal care facility. What does Nick's investigator have? Well, we have somebody who's been in the home, an eyewitness who said, I've seen a lot of dogs. Or Nick has an investigator who's gone by and has seen a lot of heads in a window and a lot more barking going around. Or an investigator has seen a lot of dogs running around the property and dog runs in the back. Nick has 3 or 4 facts that suggest to him strongly enough to raise a probability, not a probability, I'm sorry, strong enough to lead him to believe that there may be a possibility that someone's violating the Pet Animal Care Facilities Act. We go to the district court. We say to the district court, look, we've got the statute. The statute says no person can operate a pet animal facility without having a license. For our purposes, a pet animal facility is any facility that has 15 or more dogs. We believe this facility has more than 15 dogs because we've seen 8 dogs in the window and a lot of barking in the background. We've seen 10 dogs running around the property. We have somebody who's been in the home who counted 13 dogs. Commissioner of Agriculture, in order to enforce the provisions of the Act, requests an administrative search warrant to go onto the property to count the number of dogs in the property. That is distinct from a criminal warrant in which there is probable cause to believe that a crime has occurred, a criminal action has occurred, that criminal activity is taking place at the premises identified therein, and that the criminal activity is tied to a person for whom or of whom the swearing agent has some credible belief is in there. When we're on the property, we're just gathering facts consistent with the Administrative Regulatory Act. When the criminal folks are on the property, they're gathering evidence to prosecute a criminal crime. And this became crystal clear to me in a trial in Montezuma County in October when defense counsel, who was far more well-versed in the criminal law than I was, filed a motion to exclude evidence obtained from the administrative search warrant. I ran around the office talking to every administrative lawyer in my section. Has anyone dealt with a motion to exclude evidence obtained by virtue of an administrative search warrant? No. We dug through the case law. We found some cases that we sort of shoehorned into a response to this, show up in the courtroom. Defense counsel goes first, gets up, makes his argument. The judge stops him at the end and says, but what is your law to support excluding evidence obtained from an administrative search warrant? This is a regulatory act. The commissioner has an obligation to investigate. The commissioner was out there taking information related to the regulatory act. What is your case law? The defense attorney didn't have any case law because none exists. They're 2 entirely different things. So when you see the word execute search warrant upon consent or upon obtaining an administrative search warrant, I don't think the statute says administrative, but it is administrative. That's what we're talking about. I draft those in tandem with the investigator, the agent who's doing it. The agent goes to the district court. The district court gives you the warrant. You go out. Typically, you'll go out with law enforcement for your safety. You're out there to gather evidence related to the enforcement of the regulatory act. And that's the big distinction between administrative and criminal and what we're doing there. Any questions on administrative search warrants? Okay. They're really, think about them in the context of like restaurants with the Department of Public Health and Environment. They have a right to be there, but the restaurateur won't open the restaurant. They get a warrant and say, we got to go in and swab and sample all your food stuff. We don't care if it's 5 p.m. during the height of your dinner rush. We don't want any more people dying tonight. So that's that. All right, on the civil side, we can issue cease and desist orders. Yeah, I'm sorry.
So just to be clear, a criminal case can proceed with evidence that was obtained in an administrative search warrant.
That's not a yes/no answer. There are certain circumstances where it will, there are other circumstances where it won't. There are circumstances where the evidence obtained might lead to a subsequent criminal search warrant. So again, this is that work with your prosecuting attorney. Hey, I'm a BAP agent. I was out, with my administrative search warrant, and I saw X, Y, and Z. This is evidence that there could be more. What do you want me to do? Do you want me to tender this evidence to you? Do you want to execute a criminal search warrant for law enforcement to go back out and reobtain this evidence in a different way? Make sure that you're working hand in glove with your prosecutor on that side, so that that prosecutor, again, can prosecute your case and not dismiss it out of hand. Okay. CDA can issue cease and desist orders. We can petition courts for hearing on fitness of ownership. We must do that when we've taken an animal. We can request temporary restraining orders or permanent injunctions for what are violations of the act. Criminal side, you issue your summons and complaint. After we do what we do on the civil side, we can also take charge of, remove, or provide for when life or health is endangered. On the criminal side, there's the seizure and impoundment under 189204.5. Civil side, hearing on fitness of the particular animal taken, not as to all animals, usually set within 3 to 5 days. On the criminal side, you've got your cost of care and probable cause. On the civil side, we're determining fitness of ownership. Fitness of ownership as to that animal, as to that person, whether the person is known or unknown, which is an interesting piece of the statute. We have broad authority we can even go so far as publication in a newspaper of general circulation to let a person we believe to be the owner know of an upcoming hearing. We don't have to affect actual personal service, although we certainly try to in every situation. On the civil side, determination of fitness. On the criminal side, you're setting for criminal trial. Civil side, we're awaiting trial perhaps on a permanent injunction. Criminal side, you're still awaiting trial and sentencing. On the civil side, we're already to injunction. On the criminal side, you've got a misdemeanor conviction. So I show you these to let you know we have some really quick, immediate effects on the civil side. These do take a lot of manpower, person power, as Becky and Dr. Deal and Taylor recognized from the Montezuma County incident last year. But there are some swift remedial actions, there are some swift, really aggressive actions we can take. And then you've got the criminal side, keeping in mind all the time, a criminal conviction is a criminal conviction. A second one is a felony, and you're talking about things that get worse and worse for the person who's been convicted. On the civil side, yeah, we can order a person to cease and desist from failing or refusing to provide food. We can go back out and get an injunction ordering that person to pay food. They don't comply with the injunction. We can send them to jail for 5 days. We don't ever get that conviction. In some instances, what we can get will work out being better and stronger. Wagner's a really good example. We prosecuted that case. He called them 1,200 head. We found 900 head. Not living. We had 153 head dead of a total herd of 900. But we permanently restrained him from ever owning livestock because he fundamentally did not understand how to raise cattle at 10,000 feet on the open range without supplementing their feed when the ground was completely frozen over. It can be done, right? You can raise cattle at that elevation, but you got to feed them. The court got the fact that he didn't understand how to raise those cattle based on our evidence, which showed this progression of livestock that were just swooning down toward ongoing death. And the court said, fine, permanently restrained from owning cattle. This was good news because when the district attorney prosecuted the case and won a single count of misdemeanor animal cruelty, Wagner appealed that. On an evidentiary issue, the Court of Appeals overturned the criminal conviction, and what stood was the permanent injunction from the Department of Agriculture. And what still stands today is the permanent injunction from the Department of Agriculture. So this is why it's important that we all work together, that the AG's office work with the prosecuting attorneys when we've got a complicated case, that Becky's looped into as much as she possibly can be when we see a possibility for the Department of Agriculture. And we kind of have some brainstorming sessions and think, what's best for the animal? What's best for the locality where you're situated? What's best for the politics? What's best for the optics? What's best long-term for what you're doing and for the health of the animals overall? So that was a soapbox, but I'm lecturing. Okay. Becky, we have 18 minutes left. We're going to power through. I'm going to ask you guys to hold your questions unless it's really pressing, and I'll be around to answer afterward if we can. Let's talk about civil actions in the context of livestock. The acting entity in a civil action in the context of livestock is always the Commissioner of Agriculture. The standard is always the same. The animal's life or health is endangered. The commissioner, when finding that the animal's life or health is endangered and when the commissioner wants to take the animals, must get a court order. The commissioner has no authority to remove livestock from anyone's premises without a court order. The commissioner has the authority to take charge of, provide for, or remove from the premises pursuant to a court order, and then the due process procedures kick in and requires a prompt hearing in district court to determine the fitness of ownership, that person's fitness to own that animal, and perhaps an immediate filing for TRO or permanent injunction. We may not always go to TRO or permanent injunction. What is important to note here is the commissioner needs an order to take and also the due process. Compare on the civil side and the criminal side. The due process on the civil side is built into the statute. The commissioner shall petition a court of competent jurisdiction for an immediate hearing. On the criminal side, no person shall be deprived of his property. How do we do that? We set it for trial. The person has a trial, not presumed innocent unless proven guilty. Due process protections. No person shall be deprived of his life, liberty, or property without due process of law. That's how we protect it on the civil and criminal sides. I'm going to skip over these. You all know these cases. If you want battle scars and battle wounds, we can talk offline some other time. Title 35, civil actions in regard to companion animals. Again, who's the acting entity? The Commissioner of Agriculture. General Assembly gave the Commissioner of Agriculture the authority to do all of these things. Gave the Commissioner of Agriculture the authority to enlist and commission commission Bureau of Animal Protection agents. Gave the Commissioner authority to pull from the general public, law enforcement, nonprofit, municipal, sheriff's offices. All of those folks can be BAP agents. Commissioner works through all of you. All of you answer to the commissioner, and any action you take when you're enforcing the civil code is that of the commissioner. And I do want to put a really fine point on this. I cannot file a lawsuit in the name of the Commissioner of Agriculture without having permission from the commissioner. If you take a companion animal and you have not conferred with Becky, I have an obligation under the law to file a lawsuit. That lawsuit must be in the name of the Commissioner of Agriculture. We don't have permission from the Commissioner of Agriculture. I'm at an impasse because I can't file a lawsuit in any individual's name, especially a cabinet member's name, without having the imprimatur from that person. That imprimatur comes from Becky, who has someone above her, who has someone above her. There are delegations and chains of command that they have streamlined this so that it can happen efficiently and effectively, but it can't just happen. If I go into court and I have a petition with the commissioner's name on it and she doesn't know about it, you may well never see me again in front of you. Maybe you want that. All right, options. Again, take charge of without a court order, provide for, or remove from the premises. Due process, again, requires the same thing, a prompt hearing in district court to determine the fitness of ownership, perhaps a filing for permanent or temporary restraining order. We have some examples of these, frozen puppies, a number of different ways that we've dealt with this. I'm not going to go through those as well. What triggers a court hearing? We come back to the due process issue, right? Commissioner deprives a person of property, due process. No person shall be deprived of life, liberty, or property without due process of law. A fundamental foundational concept of the Constitution of the United States, also brought into the Constitution of the state of Colorado. The court intervenes to provide due process by virtue of the hearing. And the legal questions for the court when we get to the hearing are two. One, is the person able to adequately provide for the animal we've taken? And two, is the person fit to own the animal? Now, how do we prove this? What are the elements to prove? The elements to prove are important to you because that articulates and defines what evidence you're trying to gain and gather while you're in the field. It also helps you understand how to communicate to Becky what you're seeing. Calling Becky and saying, we got to take this dog right now. Becky's going to ask you, what is the evidence? I need to know the evidence. I have a dog in front of me with a broken leg, 2 puppies lying by its side, three puppies, we'll call them 3, 2 of which are panting heavily, their eyes are half closed, the third is deceased. Those are really good facts. Becky's gonna be like, let me just walk over real quick and talk to Maggie. Great, okay, we're ready to go, let's get it done. Becky needs to know these things. So these are your elements. What we look for, able to adequately provide. Remember, 2 questions before the court, adequate provision and fitness to own. Adequate to provide, lack of feed, lack of water, lack of shelter, animals dying or dead from starvation, dehydration, lack of ordinary veterinary care. Ordinary veterinary care is not vaccine, it's not worming. Ordinary veterinary care is, gosh, that wound looks like it's been open and festering for about 6 weeks, and it's getting worse, and it's infected, and I can feel the heat rising from the flesh. Why has a veterinarian not been here? Oh, I didn't have the money to pay for it. Well, that's not a defense. Fitness to own the animal. What are we looking for? The person is incapable of understanding the needs of the species. This was the Wagner case, right? He didn't really understand. He thought he did. He told us he did. For what, Bobby? 5 years he told you he did? 10 years he told you he did? Yeah, that he knew how to raise cattle up there. Cattle kept dying. Something was wrong. Consistent examples of mistreatment, neglect, or abandonment. Not the one-off, not the person who just had something horrible happen in his life and wasn't able to take care. That's an intervention. That's not a reason to take. That's a reason to help. Maybe it's a reason to say we can take this animal off your hands if you don't think you can continue taking care of it. But we're not looking for the one-offs. We're looking for a series of events that lead us to believe that there's a significant problem here. Mental infirmity, physical infirmity. All right, cease and desist orders. Quickly, a CDO is a lawful order of the commissioner. It orders a person to cease and desist from violating a provision of the act. The statute requires a couple of things. First of all, there's no hearing, there's no trial. These don't go into state district court. They're permanent in nature, but as we move away from their issuance, they become less enforceable. The elements are, commissioner, this comes straight from the statute, has reasonable cause to believe that a violation has occurred and that immediate enforcement is necessary. So these really are, like, get in there quick, we have a problem, let's get a cease and desist order in place so we can start really tracking this person and get him back on track. Or as a person to cease violating any provision of the Animal Protection Act. The way we use these largely with Bureau of Animal Protection is a backwards way. You are hereby ordered to cease and desist failing to provide adequate feed. Cease and desist failing to provide veterinary care. Cease and desist from failing to provide food adequate for the species in the manner set forth below. There have been a couple of times, we don't do this too heavy-handed, a couple of times where we've given some guidelines as to what these species would need in order to come up to a normal health and a normal weight without being overly prescriptive, because guess what? Somebody has to police this. Somebody has to police what we put in there, and we don't want this to be so onerous that Becky and her limited staff are having a nervous breakdown trying to get around to enforce 14 different cease and desist orders across 64 counties. Elements of a CDO. We have to tell the person what provisions of the act have been violated. We have to give specific facts that constituted the violation. It can't just be stop violating the act or you didn't feed an animal. Really it is. On December 13th, 2022, 14 head of cattle did not have adequate feed. On December 15th, 2022, 14 head of cattle did not have adequate feed. You know, we've got these facts, these very specific facts. You are hereby ordered to cease and desist from violating the act by failing or refusing to feed the animal, something like that. And then a requirement that all action causing the violation be ceased. CDOs are issued by the commissioner. They have the signature of the commissioner or the delegee on them. CDOs are drafted by the Department of Agriculture with the assistance of the Attorney General's office. Because it's the commissioner's signature, these must be issued from the Department of Agriculture. You'll work with Becky. Becky will tell you when she wants to issue the CDO. Come to her with the facts. The way a CDO is useful is it really can stop someone from doing something where you may not really think that there's enough here to prove a criminal violation. You don't think there's reason that the commissioner wants to take the animals, but by gosh, something needs to be done to intervene in this situation, and we think we can do it with a little bit of education and a helpful tool here. The effect of the CDO, quasi-permanent in nature, it stays on the books. Because immediate enforcement is kind of the linchpin to a CDO, commissioner issues when immediate enforcement is necessary. We had someone 5 years ago who wasn't feeding his cattle. we have the same situation 5 years later. I'm going to be hard-pressed to tell Becky, oh yeah, let's go for an injunction because we warned him 5 years ago. We need to rebuild the case, maybe start with another CDO or something else. Because they also trigger a right to a hearing. The person can request, if he believes or she believes that in fact there is no violation, then that person asks for a hearing. We're often the Office of Administrative Courts, which is my least favorite venue to litigate for a variety of reasons that I won't go into on the record. But anyway, they can challenge it, is my whole point. The statutory remedies of failure to comply. The statute says a person must comply within 24 hours. In both PACFA and BAP, the way we've approached that is really with consideration of the circumstances. If it's impossible for the person to comply within 24 hours, we put a compliance deadline in there. There's always a compliance deadline. Sometimes it's 24 hours, sometimes it's 7 days, but sometimes it cannot be done in 24 hours. So the statute says 24. We fiddle with that a bit so that we can make it most effective. Subsequent violation that is within a relative amount of time could lead to a suit for temporary restraining order or injunctive relief, which we will talk about now. Becky, how am I doing on time? 7 minutes. Okay. You're going to be pressed for your next break. Hope you didn't drink a lot of coffee. The TRO, let me just put all these slides up here so you can read them as we're talking about them. So, again, sufficient evidence. The commissioner has sufficient evidence to believe that a person has engaged or is about to engage in any act or provision that constitutes a violation of the Animal Protection Act. TRO, temporary restraining order. P, a permanent restraining order, and preliminary injunction. 3 different things, they all flow from the same. Temporary, preliminary, then permanent. What do we need in this? We need the name of the party. I need to know who owns, not just who has or whatever. I need to know who owns the animal. If you're investigating with the sheriff, the livestock, we need to know who owns the property. You all know this. Landlords will rent their property to other people to run their cattle on. We want to know the name of the property owner because it may be the property owner is also an absent herdsman, and we want to put him on the name of the suit to get somebody who actually cares named and get this resolved. We need to know the jurisdiction. When you're out there in those rural counties, know where you are in the county. The lines can be difficult when you're out in the middle of nowhere. Drop a pin, come back. Taylor's gotten really good with the county's assessment. Thank you. The assessor's pages. They're a great tool, free for everyone to use. They're all a little bit different from county to county, but with a little bit of monkeying around, you can figure out how to get the information you need. Allegations, what you're alleging happened, what I have to put in there, what facts do we have to support. The evidence doesn't go into the civil suit. The evidence stays aside. It's what I use to prove it, but I need the evidence before I can draft the complaint. Rule 11, those of you who have never seen the movie may not enjoy it. The whole point is attorneys have to have a basis, a reasonable basis of the allegations that they're putting into a complaint, a basis to believe that there's that there are facts to support the evidence, the allegations they're putting into the complaint. I can be sanctioned for making claims when I don't have the evidence to provide it. So when you get a call from Becky saying, Billy's asking me for, it's not Becky being a pain, it's not me being a pain, it's me wanting to keep my license to practice law and not be embarrassed. My embarrassment reflects on the Commissioner of Agriculture. The last thing I want at any point in time that I'm in front of a judge is for the Commissioner of Agriculture to get a black eye, because that makes it harder for all of you to prove your next case. So we have good graces in the district courts. We need to keep it there. We keep it there by taking good cases, having solid evidence, not embarrassing the Commissioner, the Governor, or any of you. All right. The effect of a civil injunction is we start out with the TRO. The temporary restraining order is issued ex parte. So I go to the court and I say, hey, we need a restraining order for this. It's an emergency. We ask you to issue it ex parte. That means there's no hearing. We're outside the context of even the defendant knowing what's going on. The court issues the ex parte temporary restraining order. We have 14 days to move into court to get this set for preliminary injunction. During those 14 days, we're trying to serve the defendant. I go back to the statute, which says we don't always have to serve the defendant if the defendant's not known. Publication, we have to make a good faith argument to the court of the steps we took. We go back to the court and we make our argument for preliminary injunction. Preliminary injunction continues the temporary injunction for a period of time up until there's a trial set on the permanent injunction. preliminary and permanent can be compressed into one. What's the standard here? Well, first of all, the preliminary injunction, at that we have an evidentiary hearing with our burden being lower. Our burden is a reasonable likelihood of success on the merits. We don't have to prove our case. We just have to prove that at the time of the trial, we have a reasonable likelihood that we will prove our case. The relief at that point in time is designed to maintain the status quo. Defendants in the courtroom will say, the status quo is that I keep my animals. No, that is not the status quo. The status quo is that no animal be mistreated, neglected, or abandoned to such degree that its life or health is endangered. Our evidence has shown that this person, more likely than not, we have a reasonable likelihood of succeeding on this, has done one of these things that has endangered this animal. To move us back to the status quo, these animals need to be taken away, and this person needs to be restricted until the time we have a trial from owning any more of these animals. They never win on the argument that the status quo is their continuing. All right, permanent injunction. It's important to understand, one of the important thing here is that the terms of the injunction must be specific. It comes straight from the statute. Rule 65 is the rule that authorizes injunctions. There's also case law that came from a case in our office. You can't just say you are hereby permanently restrained from violating the Animal Protection Act. We have to restrain an individual specifically from acts that he or she has engaged in that constituted the violation that occurred. And if we go for contempt for a violation of this permanent restraining order, we have to show that that person violated that order, those specific terms of that order, which means it relates back necessarily to that which we proved. And when we go for contempt because the person is doing it again, we can go for remedial contempt, which is an order from the court to fix your behavior, do it right, or jail time. Nick Fisher in the back of the room sat next to me in Adams County, and we went into court, and I said, well, Nick, we can ask for jail time for this rat owner who is really awful, but I just can't imagine that the district court is ever going to give the Pet Animal Care Facilities Act of the Department of Agriculture jail time. The judge was furious with the defendant. You don't understand a cease and desist order from the Commissioner of Agriculture. You don't understand a permanent injunction from this court. You don't understand the Court of Appeals order upholding the order. You don't understand the fact that the Supreme Court of the state of Colorado denied cert on this. I'm going to give you 7 days in jail to think about this, and maybe you'll understand it after that. I looked at Nick, he looked at me, well, we got it. Not the only time, right, Nick? You guys have done it again. So jail time is a very real possibility for someone who violates a permanent injunction related to regulatory acts. And then finally understand, this was the Schumann case that I argued to the Court of Appeals. The decision became published, so this is now published law. The judges asked me in the courtroom, Mr. Seiber, how permanent is a permanent injunction? There was no solid answer to that, and even the judges themselves had to reach out into far jurisdictions to find it. Here's what it boils down to. A permanent injunction is permanent unless and until there are changed circumstances that indicate that the person cannot or will not recreate the same situation. A person could get remedial training, remedial care, remedial education, go on medication, do something, do this, come back to the Department of Agriculture, say, hey, look, my ways have changed. Great, sir, why don't you petition the court to relax the permanent injunction? We'll file a brief in response. We'll do some more interviews. We could. I've never seen that happen, but it's what I throw out to the courts, and it's also what I throw out to defense counsel when they say, well, my gosh, how long is this going to last? Well, you know what? Why don't you come back? Why don't we let this enter? You come back to the department in a year, and you tell the department how you fixed the situation. Show the department how you've built pens that actually can hold animals. Show the department that you have a solid stream of income that's going to give you the ability to purchase consistent feed for these animals. Show the department that you have a relationship with a veterinarian who can provide care that you didn't provide for the past 6 years to these animals that were dying on your property. We can talk then. I'm a little less forceful about it because I really want them to settle for injunction rather than waste the department's time, energy, and resources to go into a hearing. I use the word waste inappropriately rather than to use the department's resources to go into a court. It's not a waste. All right, civil enforcement interplay. Becky, I'm out of time, all right. Okay, these are exclusive. They're not, but they're exclusive, but they can work together. Get in touch with Becky, run your fact patterns by her, But please, come to her with evidence. Come to her with evidence. Come to her with questions too. But when you're ready to act, have evidence. Give her the cold hard case that she can't turn away from. So we've got injunctions. We can do all these things together. The last piece, really quickly, the Open Records Act. For those of you who, especially those of you in nonprofit agencies, the Open Records Act of the state of Colorado applies to you because you are acting as the Commissioner of Agriculture. You are fulfilling the regulatory requirements of 3542. Your case files, your reports, your veterinary records, your photographs. If your agency receives a letter or an email or a phone call from the press saying, I am making a public records request to your agency for X, that needs to go to Becky, who's going to get it to the public information officer, who's going to loop me into this conversation, and we're going to sit down and think about this constructively as to whether the particular records requested do constitute the records of the commissioner, which for the most part yours do, or they exclusively constitute the records of the agency or the nonprofit. And then we're going to, once we've figured that out, we're going to review the records. We're going to redact where there's confidentiality. Confidentiality is very specific, set forth in the statute. We're going to give the person a fee estimate as to what it would cost to receive these records. If the person pays the fee, we're going to give the redacted records over. If the department asks you to give the department records, please do not redact anything yourselves. That is something that only the department and I can do before we hand it off. Your obligation is just to transmit the records to the department. Do not transmit the records when you transmit the request. Just transmit. So we start with, you receive a request. You transmit the request. You wait for Becky to advise you as to what she needs next. Becky says, I need your records. Transmit the records in their native format. You're pretty much off the hook. We may have follow-up questions, something along those lines. Go from there. So that's open records. That's the, and then what is a record? Everything in writing, photographs, emails, text messages, voice messages. Anything that is in a format that is kept is a record. And that's that. Oh wait, Becky, it's not the Dangerous Dog Registry. The Dangerous Dog Registry. Look, this exists. It's not a very powerful tool. There is no enforcement authority from the Department of Agriculture with regard to how it's done. And we have no authority over folks who report. Person convicted of unlawful possession of a dangerous dog. You're trying to take a picture. I'll get you the whole slide. Okay. Person convicted is supposed to go to a veterinarian and get it chipped. The veterinarian is the one who's supposed to report to the Department of Agriculture. Yeah, the department has a database, and it shows that there is a dog with a microchip number of X whose owner was convicted of unlawful possession of ownership of a dangerous dog. It's helpful. It's not going to solve anything, but it exists. And so when you have dangerous dog situations, make a phone call. Know that this database is here. The department keeps it up as best the department can without any authority to enforce or regulate the veterinarians who may or may not be reporting. So it's there, but it's not a be-all, end-all. Thank you all for your attention. Send your questions to Becky. She'll get them to me.
Awesome. Thank you so much, Billy. That was super helpful. And I'll be sending some updates on the Dangerous Dog Registry and some ways to submit requests for information from that. We're going to work on updating that over the next few months, but it is not updated yet. Sorry. We're working as fast as we can. Great. Thank you, Billy. That was incredibly helpful, and thanks for your speed presentation at the end there. And I have your keys. And okay, so what we're going to do now is take a 5-minute break. Let's go ahead and come back right at 10:10, and then we're going to start our first of 2 panel discussions. So our panelists for the housing and transporting animals panel, if you could come up here, sit at these chairs up here and get ready to go. Thanks so much.